Hi everybody, Trademark attorney Josh Gerben. I'd like to talk about what is a notice of opposition or an opposition proceeding at the United States Patent and Trademark Office. Now, if you have received a notice of opposition or are considering filing a notice of opposition against another trademark application, it's very important to understand what these proceedings are and how they work. So every trademark application that gets approved by the United States Patent and Trademark Office for registration has to go for a 30-day period of public comment or for potential opposition. During this 30-day period, anybody that thinks they could be damaged by the registration of the trademark can file this formal notice of opposition. If you're filing a notice of opposition or have one filed against you, you are technically in an administrative court called the Trademark Trial and Appeal Board. So the Trademark Trial and Appeal Board, or commonly referred to as TTAB, is an administrative court within the United States Patent and Trademark Office. So there's real judges. It's just that because it's an administrative court, they're not going to ever award damages or attorney's fees. So these opposition proceedings are solely related as to whether the trademark can register or not. So very important to know that if you win an opposition proceeding or lose one, you can stop a trademark from being registered, but you cannot obtain damages or attorney's fees against the defendant. And even more importantly, you cannot stop that trademark from being used in the marketplace. So it just stops the registration process. It doesn't stop the actual use in the marketplace of the trademark. If you're looking to do that, you have to file a lawsuit in federal court. So now that we know a little bit about what a notice of opposition is, I'd like to talk to you about how they work. Because the biggest misconception we see about opposition proceedings is that you can file a notice of opposition or have one filed against you, and then the government will just decide the case, like without anything else. That's just completely incorrect. The filing of a notice of opposition starts a legal proceeding. The case, if it goes all the way through to a final decision, will take typically, at minimum, a year and a half. A year and a half. When you get the initial trial calendar when these oppositions are filed, they go out a year and a half to get to a final decision, at least. And most of the time there's delays and it's going to take longer. So just keep in mind, these are not short proceedings. Now, once an opposition is filed, the defendant will have 40 days to file an answer. So that's the initial part of this. You file the opposition, the defendant has 40 days to file an answer. If no answer is received, then you might be able to get a default judgment, okay? And a default judgment would end the case, and that can typically happen in about 3 to 4 months. So a lot of folks file oppositions hoping they might not even receive an answer and get that default judgment. But if an answer is filed, the next step is to go to discovery. Discovery is a phase where the parties will exchange requests for information, so this could be requests for documents. They can ask questions upon officers of the opposing companies, can even take depositions during discovery. So this phase itself is normally going to cost somebody at least $10,000 or more to complete in full. And for that reason, many cases will actually settle at the outset of discovery. So when the parties start exchanging discovery requests, everybody realizes the expenses are about to get real. And a lot of times the parties will come back to the negotiation table to try to find a solution to the problem before they have to pay the lawyers a whole bunch of money. Now, if your case does make it all the way through discovery, the next step is going to essentially be the trial or testimony period. This is where you're going to take a lot of depositions of your own folks and of folks from the opposing party. Once those depositions are complete and discovery has been completed, now we get to the trial period where you start to write briefs. Okay, so you start to put your case in a full formal brief for the judge to decide, and the other party will do the same thing. Once the cases are fully briefed, then it finally goes to the judge for final decision, and that can take another couple of months to get the decision out of the Trademark Trial and Appeal Board. You can get through these whole cases without actually appearing in court. Okay, so these are an administrative proceeding. Again, it can all be done in writing. Parties can request an oral hearing at the end of the case to make the oral argument in front of the judge about their case. But not everybody does, and many of these cases will be decided without ever even appearing in front of the judge. So I hope this video has been helpful in understanding the scope of an opposition proceeding, how long and expensive it can be, but also that there's ways to try to resolve these things before they get into that deep expense, mostly by trying to settle with the other party and finding common terms that you can all agree on to move forward. If you have any further questions about an opposition you would like to file or one filed against your trademark, please feel free to get in touch with us.